And this webinar is part of that wider process. And what we're really keen to do today is really try to understand what's happening from a business perspective in relation to a number of the important updates which have taken place related to right to work checks, with further changes set to take place from the 1st of September. So as you know, at the end of August, temporary concessions which were introduced during the pandemic, which enabled employers to perform right to work checks virtually, came to an end. But what are the practical ramifications for businesses, and what are the tips and advice that they need moving forward to adapt to the new scenarios? Well, I'm delighted to say that we're joined today by Omer Simjee, who's the managing partner and founder of Magma Legal, to talk about these specific points. So in terms of a specific format of today's session, very soon I'll hand over to Omer just to run through some of these main points, and then what we'll look to do, that should take us to around about 11:30, and that will leave us with about 20 to 25 minutes of time for questions and answers. So again, if you've got any specific questions, feel free to post them in the chat box, but also, again, if you've got any specific questions or points throughout the presentation, feel free to leave us a message, and I will obviously direct those to Omer afterwards. And just to say as well, before I hand over to Omer, what we'll look to do this week, we have got another webinar which is coming up tomorrow, which is focusing on Brexit grace periods. Again, you might have seen the news around the delay to transitioning to UKCA markings overnight. So again, that's something that we'll be looking to discuss tomorrow. And we'll be joined by William Bain, who's the head of trade policy at the British Chamber of Commerce, and Nicholas Smith, who's a partner at Squire Patton Boggs. So again, if that's of interest, please do visit our website, and we can share the links in this in the chat function here as well, if you'd like to attend. So without any further delay, I'd now like to hand over to Omer. Omer, over to you.
Great, thanks very much, Raj, and thanks everyone for joining today's session. I think really just by joining today's session, you've taken a big step forward to support your own organisation to avoid any banana skins when it comes to these right to work checks. The banana skins in this case are pretty serious because if we get things wrong, then it could result in a civil penalty for up to £20,000 per illegal worker. And even worse, if the organisation knowingly employs an illegal worker, then there could be criminal sanctions. And for both of those, the sanctions could apply to all those involved in the recruitment chain, right up to the board of directors. So this is definitely one for them to set up and take some notice of. I think that's important to say, particularly in the context of where we are at the moment. Hopefully, I just had a chat with Raj just before this call, and he fed back that the membership are seeing significant recruitment challenges. And I think that can only put the pressure on HR to find the right candidate and get them in the door, and perhaps ask questions later regarding their immigration status. So I think that makes this session all the more poignant, but I can only emphasize that to recruit in haste could attract some quite serious repercussions. Okay, so let's go on to look at some of the detail and what's coming up. The important thing is, first steps, and this hasn't changed, your right to work checks need to be completed before employment commences. That's really important because, again, links back to what I said just a moment ago. The temptation is to make the offer, get the candidate in, and then ask them for documents on the first day. That's not really going to wash. I think there's a lot of temptation, I think, to also perhaps get the candidate in at 8 AM on the day in question before they actually start work and start to do these checks. But that also is going to be problematic, particularly if the employee can't supply what it is that you need. And certainly recruitment isn't going to be looked upon favourably if the directors determine that, well, the person that they're expecting to start can't start because they can't produce the right documents. So a lot of today is going to focus on manual checks and online checks. Manual checks, to a large extent, are the processes that you are already familiar with, just subject to a couple of tweaks. The really new part here is the facility to be able to do an online check now. And so I'm probably going to focus on that a little bit more. So manual checks, who can you do them for? Well, you will continue to do them for UK and Irish citizens. And we'll come on to talk about a particular cohort of people who may not wish to engage with the online process. And I'll say a bit more about that in the coming slides. But firstly, these three words should resound with you if you're responsible for onboarding staff: obtain, check, and copy. At its heart, those three steps have not changed from the previous process. That's obtaining your originals of acceptable documents from the Home Office's right to work checklist, which is broken down into list A and list B documents. You need to make sure that you obtain and see genuine documents. Make sure that the candidate is actually permitted to perform the work in question. Where might that be an issue? Well, sometimes people have certain conditions and restrictions stamped on their permits, say that they can't do certain activities, or possibly even that they need to report into the authorities on a monthly or bi-monthly basis. Having checked those documents, then you will need to take a copy. You will need to note down the date that you have seen the copy. And then this is a step which is often missed and overlooked. It needs to be transferred into a secure and non-editable file and retained for the period of employment plus 2 years. That's really important, because just simply taking a copy of the documents, inspecting the original against the likeness of the person in front of you isn't enough. If the Home Office were to do an audit of your practices, they would want to see all copies of right to work documentation on a effectively an online system. They would want to know who they need to go to ask for that documentation, and they would expect it all to be readily available. I'll give the example of a client of mine with headquarters in Manchester and a number of other sites around the country. And its employment practice was to have each of the different sites, branches, perform their own right to work checks. And then those documents were stored locally. Their copies were not taken, put into a central online system, which meant that when the Home Office turned up at their premises in Manchester, the client in question wasn't able to get hold of the copies, the secure copies, which was a problem in that case and did lead to an improvement notice. So make sure you have a centralized system in place, as I think the learning from the manual checks. Okay, moving on to the new online checks. So, of course, pre-Brexit, your checks on EU nationals were fairly straightforward, but of course now they can't just rely on their passport or national identity card. They will now need to engage with something called the View and Approve service, which effectively gives them what we now call an e-visa. So lots of new terminology here: View and Approve service and the concept of an e-visa. So at any one time, an individual should be able to go into the View and Approve service and be able to see their existing immigration status. So currently, this system isn't available for British and Irish nationals, so you'll still need to do a manual check for those nationals. So this View and Approve service effectively applies to everybody else, including EU candidates with an an application under the settlement scheme, hopefully confirmed application, either giving them settled status or pre-settled status. And that will show up within the system. Now, what may not show up in the system is an EU candidate who's in the UK and who's made an application under the settlement scheme, but they haven't received an outcome to that application. So in that case, so long as the individual can prove to you that they made an in-time application, then that will be sufficient for them to continue to work in your organizations. Now, what would be an in-time application? That would be one technically made on or before the 30th of June. So again, not enough just that you see that they have an application outstanding, it is that that application also needs to have been made in time. So let's take a look at what you'll now see within this View and Prove system. Your applicant will go into that system and they will generate what is now called, again, new terminology, a unique share code. And once they do so, then we can see the screenshot that we've taken there, things to look out for. There's date of birth and share code, and also talks about the date that the share code will expire. So that share code is going to be valid for 30 days. The share code is passed to you guys, the employers. It can either be done via the service or the employee can just simply pass on the code to you. That's fine either way. And you will then go into the employer section of the system to look at the immigration status of your candidate. So here we are. You've gone into the system and you can see on the snapshot there that this employee has a permanent right to work in the UK. They can work in any job, which is great. There's no limit on how long they can stay in the UK, which is also great, which means that this individual has most likely been given either indefinite leave to remain or has secured settled status. Now, it also gives you some handy tips on what to do next. If you employ this person to avoid a penalty, you must check that this looks like the person you meet face to face. So you still need to do somewhat of a further check. So not enough that you have gone in and used the online system, you still need to check the likeness of the individual when you either see them perhaps via a Zoom call as we're doing now, or when they or prior to them starting work for yourself, in order to secure that all-important defence from prosecution. Once you've done that for someone who has the permanent right to work, you don't need to make a further check, which is very helpful. Let's look now at somebody who has limited permission to work in the UK. So with this individual, we can see that they have permission to work in the UK, it's theoretical here, until 28th of April 2023. So what you will be doing is you will be putting a date in your calendar, ideally 3 months ahead of 28 April 2023, as a reminder to yourselves to ask, well, I guess, give the employee a nudge to say, look, now, Erica, you doesn't look much like an Erica here, but they would need to make some sort of extension application or an application to permanently remain in the UK. Helpful for them and also helpful for you, because it means that they're not leaving it to the last minute to do that. And again, you've got some helpful additional instructions here on this page to avoid a penalty, either a civil penalty or a criminal prosecution. check that this looks like the person you meet face to face, and all importantly, keep a secure copy of this online check in your central system that I was encouraging you to form earlier. And do the check again before the permission expires on the date stated. There's also a bit of a sort of innocuous comment here saying, read the employer's code of practice to find out more about right to work checks. I would very strongly encourage you to do that, and also to retain a copy of that code of practice and keep that on your central system. Because again, if the Home Office turns up at the workplace and says, right, Joe Bloggs, tell me, what do you understand about your obligations to comply with right to work checks, they're going to have expected you to have seen and read that code of practice. So it's important that you familiarize yourself with its contents. And because that code of practice will, of course, update from time to time, that's why I say it's useful to download a copy of the code so that you can say to the Home Office inspector, well, at the point that I did the right to work checks for Erica, that was the relevant code of practice in effect at that time. Okay, so I talked earlier right at the start about potential banana skins. So if you are doing the checks and you find out that somebody's permission has expired, that doesn't mean definitively that that person doesn't have the right to work, because right to work is a very broad-ranging concept. And what years of experience tell me is that quite often when somebody doesn't have a permission in one area, it's quite possible that they might have permission in another area. Circumstances may have changed. They may have married a British citizen. They may have ancestry rights. So it doesn't mean to say that if you've done your online check and it looks like somebody's permission has expired, that that person is de facto illegal. What you would then move on to do is to use the employer checking service, as you will be used to try and get a positive verification notice, i.e. hopefully doing that further online check will throw up some clue as to whether or not the person has made some other application to remain in the UK. So that is very important. Third-party checks. So it'd be very tempting, I think, to say to a third party, look, can you please do all the right to work checks? It might even be that you're using an agency to vet a candidate. Well, any checks that an agency does for you aren't going to count towards fulfilling your obligations to do your own right to work checks to give you a statutory excuse. So I think that's very important. Often something that I see being missed. It's very important that your own team do your own right to work checks. Next point then is one of consent. You can't force a candidate to use the online system. If they want to use the, if they want to do manual right to work checks, then that is their prerogative ultimately. So do bear that in mind. Now, of course, if they're refusing to do any engagement with right to work checks, and that's a separate issue, that potentially means you're not going to be able to onboard the individual. But consent is very important because, as I say, you do need that consent to be able to use the online systems, including the employer checking service. But consent is also going to be important from your favorite topic, GDPR, which of course always rears its ugly head. Do be mindful of your GDPR obligations. Hopefully by now you will have reviewed your wider processes. Perhaps you'll have a candidate privacy notice. Hopefully when you issue your offer letters, you'll be sending your own privacy notice at that time. But of course, through the onboarding process, including using the online systems, it would be useful to put something in there for the employee to give their marked consent, i.e. for them to sign and return something to you, rather than you relying on implied consent, i.e. something in your letters which say, well, look, this is how we're going to process your data and this is what we're going to do with it. So if you haven't already do so, this is a great time which to just think about your online processes, reconsider your offer letters, and if you're doing that, then also think about how it is that you're going to secure consent. Well, discrimination, why is that in there? I've put the word justifiable. I'm not saying go ahead and discriminate broadly, folks, although that would result in a lot of work for me, which would be great. What I'm saying there is whatever processes you put in place can't just attach to EU citizens or people that you think might not have the right to work. Your systems need to be the same for everyone. So why have I said the word justifiable in there? I've added that because if somebody does say that your practices are discriminatory, then you might be able to run a justification argument, which would give you a defence against prosecution, or at least against a claim of discrimination. You'd say, well, look, we apply the same systems to everybody, so they don't impact on any one group more than another group. So potentially we have some defence there. Big Brother. Right, so just a new consideration for you guys in terms of the new online systems for these checks, the view and prove. Note that the authorities, particularly, I think the important ones here, Home Office, of course, Department for Work and Pensions, HMRC, they can go in without permission to have a look at the view and prove. So if you get in hot water with the Home Office for a potentially illegal worker, and you are running the point that, well, yes, look, we did use online systems and they came out with a certain outcome, well, the authorities can be able to check that. So I think it's good from the perspective of it will cut down a lot of fraud and falsification of perhaps right to work evidence from the employer's perspective, but it also means that it's going to be easier for the authorities to prosecute where the right checks haven't been done. So just be mindful of that. Okay, so we have a little bit of an interim period, not much left of it now, but between the 30th of March and up to the end of this month, we have something called adjusted right to work checks, which were adjusted to reflect the pandemic and the fact that it wasn't always going to be possible to do manual checks. It wasn't going to be possible to see somebody in the office and check their likeness. And so the Home Office relaxed checks for some time to say, well, okay, it's fine. Look, we're all operating from Teams and Zoom. So you can now do your likeness checks over a video call. But when you do your checks, then there was some added wording for you to put in there to mark that the adjusted right to work check had been undertaken on date due to COVID-19. Now, I'll be honest with you, a lot of companies haven't been doing that. They've been doing the standard right to work check because they weren't aware that the additional wording was needed. So does that put you in a blind panic? Well, not necessarily, because Home Office is saying that retrospective full checks aren't necessary, but that's full checks as in the in-person checks. So what I would say to you is that this is a good time to do an audit of your files and your onboarding, certainly since 30th of March 2020. At the very least, make sure that you did take the correct right to work documents. If you didn't write down the correct wording, then at the very least, then add an additional line now to say that an adjusted right to work check was done. The recommendation was only for the date, but I always recommend that the checker prints their name and also signs it just as additional evidence as to who in fact did the right to work check. If you are going to go back and do this adjusted check, then don't add a retrospective date, add the date that you are currently doing the check. Bear in mind, folks, this is only ever going to be a problem if the person that you have onboarded is illegal. So there is no prosecution for you not having done the correct checks when you were meant to have done them, or to add the correct wording now. It's only a problem if your person is illegal. So perhaps if you need false documents in some way, but the retrospective exemption applies to you basically not having to go back and do in-person checks for all the people that you did the adjusted right to work checks for. Okay. So just a quick overview where we are with the settlement scheme. So for anybody that has settlement status, we mentioned it earlier because we can see it in the screenshots. For people with indefinite leave to remain, no follow-up checks would be necessary. It's just the people who have pre-settled status that you would need to do the follow-up checks for. And I've already recommended that you diarise the dates that those follow-up checks are necessary. Now, there's been a lot, in fact, I've also said to you that that people would need to apply under the settlement scheme by the 30th of June. But what we're finding now is that the Home Office, well, I've come across some caseworker guidance, which I've quoted in the slide, which basically means that if somebody who's been in the UK, who was in the UK as of the end of last year and has been working in the UK, hasn't as yet made an application under the settlement scheme, they can still make that application where they can show reasonable grounds for having not done it. Now, this isn't advice, but my insight is that it's a pretty low threshold for telling the Home Office reasons as to why you didn't meet the June deadline. So if you do your audit, as I'm recommending that you do, and you find that somebody didn't apply under the settlement scheme, but needs to, and so then they make that application, just be aware that it actually has got a good chance of succeeding at the moment. So do be mindful of that. Okay, just looking at the other options in terms of permissions to be here. There are certain people called frontier workers who can dip in and out of the UK. So you also need to be mindful that if they are working in your organisations, that the various online checking services might throw up that somebody has this new permission to be in the UK as a frontier worker. So just be aware of that. And if you have, if there is somebody who's thinking of applying for it, then they need to be mindful of what eligible work is, which is essentially work which was paid for with regular working hours. And so long as they were in the UK, that individual was in the UK by the 31st of December last year, and has worked in the UK at some point, then that's something they'd be eligible to apply for. So just be aware of that as an additional option to the settlement scheme. Otherwise, study visas, just things to work out or look out for, which go hand in hand with checking. I mentioned earlier that the checks might throw up that there are restrictions on the ability to work. Well, if somebody's studying in the UK, there will be restrictions on the hours that they can do, typically up to 20 hours per week in term time, but no restrictions outside of that. Be mindful of graduate visas, because things really freed up for university graduates this year. When they leave university, they no longer need to be sponsored by an organisation for up to 2 years. Clients are finding that massively useful, because what they were seeing before is that they wanted to take on graduates, but they weren't willing to pay the salaries mandated and also go through the cost of sponsoring somebody that they didn't necessarily know was going to be a good fit for their organisation. So things have eased up a bit now. So be mindful that you can bring on non-UK graduates for up to 2 years without needing to sponsor them. I've had a look at the graduate visa process. It's relatively straightforward. And then otherwise, if you have somebody you want to onboard, but you don't have any other route to squeeze them into, then we are falling back on the old points-based system to try and get a skilled worker visa, or possibly an intra-company visa. But that is a separate session. And certainly if that is something that you're looking at, then come through to us and speak to us about that separately. Yeah, it is a costly and expensive process, but we do help lots of companies with that. Right, so a little bit of an action plan. Your absolute number one takeaway from today is going to be your get out of jail card, the right to work checklist. Now, I've embedded in these slides a link to that right to work checklist. It has been updated, so the ones that you've got on file, they're going to be out of date. You need to start using this new one, because it also does reflect the concept of people being in the UK with settled and pre-settled status. Now, your right to work checklist is something that I recommend that you complete for every single employee. If you keep that on file, there is no going wrong. And this checklist is also appended to the code of practice that I mentioned earlier. So if you're in the habit of filling something out for every single one of your employees and keeping that on file, that is going a long way towards you satisfying your right to work compliance obligations. So be mindful of that. As I say, I've embedded a link here. If you want a copy of these slides, then what you can do is you can send an email to my colleague Freya, and her email is at the back of these slides. We'll send you an electronic pack of these slides, and you'll be able to click on this link and get hold of the checklist. Right. So your go away points are assessing who needs to be checked. So that is effectively encouraging you to do a review of your workforce and thinking, right, well, who do we have? Do we have UK citizens? Do we have sponsored people in the organisation? Do we have a mixture of EU nationals with pre-settled or settled status? And what do we need to do to establish that we are complying with the right checks for those individuals? Look again at onboarding processes. Again, most probably your offer letter will need to be amended where you are onboarding anybody that is not a UK national or an Irish citizen. Think about your policies. I'm going to come on to that in a second. Encourage your migrant staff to keep you informed and copied. Such an easy one, but really so helpful, because if you can put in your offer letter something to the effect that an individual needs to share with you copies of all correspondence they receive from the Home Office, that's going to be extremely helpful. Because what I find quite often is that applicants don't want to share copies of correspondence they get from the Home Office, particularly in cases where it says something unhelpful, or at the very least, if you have asked them to keep you informed and copied and they don't do that, then it's going to give you stronger grounds to go on to the next step, which is to take immediate action to either discipline or dismiss. Now, certainly if somebody is not complying with right to work checks, they're already in the organisation, then the very first thing you want to be doing is calling them to a short notice disciplinary hearing. And if they don't produce the right documents at that hearing, then you should be dismissing immediately. SOSR means some of the substantial reason. That is a reason for dismissing somebody where you are unsure of their immigration status. There is also the right to dismiss for illegality, but it's slightly more complex and risky. So that's something you'd want to take advice on before you do it. But it does go back to your policies, because what is pretty much essential for onboarding anybody who's not a UK national is a specific process dealing with right to work issues, whereby you will have a shortcut process for calling people to a disciplinary hearing and dismissing them. And that is something that the Home Office will expect you to have as well. So think about having a bespoke process for that. Okay, so you can see my contact information there, the phrase information, and we'll open up for any questions.
Thank you, Omer. So that's a fantastic update. Really, really helpful. I think really great that you've obviously put in the checklist as well in such a clear and concise fashion in the steps that organizations need to take. And again, we can share Freya's details on the chat function here as well, in case any organizations have specific questions that they would like to follow up after this session. Now, we've got around about 20 minutes or so before the end of this webinar. So again, obviously, please feel free to have a think about any questions that you'd like to ask Omer moving forward. But I mean, just before people come in, Omer, I've got a couple of questions I wanted to ask myself.
Sure.
So obviously you mentioned some of the potential banana skins there when it comes to, say, consent, GDPR, discrimination, as you commented on. Have there been any issues which have been more frequently encountered than others, would you say?
Well, I think something that I'm seeing companies not do is think about GDPR from a very early perspective. Certainly the candidate privacy notice does seem to be news to a lot of companies that I speak to. They're not quite sure what they should be doing. They're not quite sure how that also works in terms of where they're advertising roles as well, and where they should be posting a link to their candidate privacy notice. But what they, I think, need to understand is that from a very early stage, when they receive data from a candidate, really they need something in place already at that point. Posting a link to a privacy notice at a later stage when you make an offer is perhaps too late a stage. So I think that is something definitely for people to think about.
We're going to say, I mean, what, you know, I think we've got the question here. So what happens if a business employs someone carrying out all the right checks and it turns out that the individual does not actually have the right to work later down the line?
Yeah. I mean, that is a very important question. And I think the organization in that sense needs to be sure that they have performed the right checks. And it goes back to what I said earlier, whereby somebody does a check using the online system and they get something back which says that the person doesn't have the ongoing right to work. And even then they use the employer checking service, which also says this individual doesn't have the right to work. There are quite a few applications that can still fall through the cracks, which are applications that have been made but not received or processed by the Home Office. That kind of an application isn't going to show up on any online check. So it would be very dangerous for an employer to discipline or dismiss in those circumstances, which is why I still think that the employer needs to, in all cases, invite the person to a meeting where they are given a chance to explain what they have or haven't done at that stage, and then make a decision on that basis. But if having done all of that, they're still not getting what they need, and often not getting what they need in a timely fashion, then they need to think about dismissing. And in these kinds of situations, employers are often very tempted to say, well, we'll suspend the employee until they come up with the right documentation. Unfortunately, that act of suspension isn't fixing anything, because for that ongoing period of time where the employee is suspended, they're still on your payroll, you're still employing them. And really, you're only making the situation worse, because you're elongating the period for which you have potentially employed an illegal worker. So really what you need to be doing is moving to dismiss, and the same considerations also apply for the notice period. You don't want somebody working their notice period in these circumstances. What you want to be doing is dismissing, and then clients will often say, well, in that case, I'm not going to pay in lieu of notice, or I'm not going to pay in lieu of holiday. Well, that is the call for the employer to make in those situations, because you only be entitled to withhold the notice pay and holiday pay in a situation where the individual is de facto illegal. But the employer will not necessarily know that at the time. So when you don't get what you need from the candidate or your employee, it is a very difficult situation, fraught with a lot of risk. So I'd say get some advice if you are in that position.
I mean, yeah, and that's a really good point. I mean, just following up from that, as we know with the pandemic, obviously given the financial pressures that a number of firms have faced, particularly SMEs, I mean, what are, again, some of the financial ramifications for these organizations that don't comply with these changes?
Okay, it goes back to, it's a really good question. It goes back to something I said in the middle of the presentation, which is that you have a problem where you have an illegal worker. You have a problem where you have an illegal worker. But of course, you as the employer aren't going to know at any particular stage whether or not somebody is definitively illegal. But the sanctions are serious, and certainly if you haven't been complying with the right checks, if it's simply negligent, and this is discovered by the Home Office, then one of the things that could happen is that you are given a black mark from the Home Office. And certainly if you are looking to employ somebody from outside of the UK and potentially sponsor them, it might be that you're unable to do so because the Home Office has put a black mark against your record. So if you are a tech company and you find that you need to recruit from overseas, I don't think the board are going to look very favourably on the recruitment team if they're told, well, we didn't comply with stringent onboarding practices and the Home Office won't allow us to have a sponsor licence. That's one possible outcome. Your kind of worst case scenario is where you have knowingly employed somebody illegally, and of course then you're facing criminal prosecution.
Completely. And one question I've got, which is obviously a bit broader, but as we understand with the future of work and more organizations working from home or home working, for example, I mean, do you think moving forward that there will be more kind of digital elements involved in the onboarding process? Do you see them moving away from more of the onerous checks that have been in place for a number of years as the shape of the labour market continues to change post-COVID?
No, I think if anything, the requirements are only going to increase. Certainly, we're looking at the latest right to work checklist. It hasn't particularly been streamlined in any way. It's certainly some of the terminology has changed, but it hasn't been streamlined. So I don't see the direction of travel as being that there will be any easing up on the checks that the Home Office will be asking employers to do, which is why I think it's best to get the house in order now.
No, completely. And does the Home Office conduct random audits on businesses, or only if it suspects that a business has employed an illegal worker?
Yeah, so Home Office can turn up at any premises to conduct an audit. There are certain businesses which they like more than others, which are labour-intensive businesses, certainly. If an organisation applies for a sponsor licence, then it is very likely that that company can expect an audit from the Home Office. So that is certainly something to bear in mind. Now, just to give the benefit of a situation I encountered where the Home Office did turn up at a client site, and that client engaged quite a high number of agency workers. I mentioned earlier about the fact that a third party can't do these checks on behalf of an employer. I think that's something really to bear in mind if you are subject to an audit, because if it has been the kind of search process where the agency has located somebody and then they've passed them on to the employer, often it's overlooked as to who should have done the right to work checks. That's going to be problematic. The other thing that could be problematic is if somebody is working on your premises and they are an agency worker, but they've been working on your premises for quite some time. The Home Office is likely to apply its own test as to who the employer is. So that, again, is something to bear in mind. So, well, at the very least, you need some confidence to be able to signpost the Home Office to say, well, we're not responsible for these agency workers, they're employed by the agency, but you do need some confidence that the agency that you're using is doing its own right to work checks, as we are discussing here today.
No, that makes complete sense. And I was going to ask a question actually when you did the overview of the View Improve system and using the kind of unique share code. I mean, have there been any kind of practical issues that businesses have raised when they're trying to use the system, and that they've had issues trying to overcome those?
Quite honestly, Raj, I think employers are finding it quite user-friendly. I've sort of done a dummy run, so to speak, myself on the service, and it seems to be fairly straightforward. I think one thing to look out for is, as the employer, just make sure you're looking in the right section, because when you go in, there is an employee section and employer section, and it's the employer section that you need to drill down into.
Which is reassuring and refreshing to hear, I must say, because we've had plenty of instances where, there's been kind of submissions made for grants and things like that, where, online systems have been playing up, and we've had some negative feedback from businesses. So that is quite reassuring to hear. I mean, we've got just about 5 minutes or so left. So again, if any of the audience members have got any specific questions to have for Omer and his team before we wrap up, that'd be great to hear from them. But I guess
sorry, Raj, what I do tend to find is that quite often in these sessions, companies have pretty bespoke queries about their own organisations, which they're not comfortable sort of sharing on the chat. So if anybody would like to call us directly following the session today, they're more than welcome to do so. That's
fantastic. And I know obviously we've got your details on the screen there as well. So again, if anyone has any direct queries for Omer and his team, please do get in touch. I mean, I guess obviously we've got around about 5 minutes or so left. And I guess my question to you is, if there's one piece of advice you'd give to businesses in relation to this topic, what would you say it would be?
It would definitely be to use the time now to assess what you have, who you have, and really nail down the dates for renewal. I think the major problem that we see is with the dates of renewal, that they're not diarised. And again, the Home Office expects employers to have them diarised. But the dates for extension applications and everything often are left at the last minute. And that puts pressure on the individual. It puts pressure on the organizations, and it potentially can also lead to some pretty uncomfortable situations that I've seen where the employer hasn't been able to identify at all that any kind of an extension application has been made, and they're left with no choice but to dismiss the employee. That's obviously not only just upsetting for the individual who has been dismissed, but then the employer has lost a key component in their workforce. So, you know, and then quite often then I'm contacted and being asked to provide a magic bullet for the situation, which is quite difficult to produce because everybody's run out of time. So with time, we can always resolve a bad situation, but without time, it's very difficult to turn that around.
Yeah, so get checking early and get everything in order as soon as you can. And then I guess one final question, you mentioned the employer checking service. I mean, can this be accessed via the View Improve service?
No, so the employer checking service is still a separate service that you need to use. So it's not an all-in-one at the moment. It's because really the circumstances where you're going to use the employer checking service are slightly reduced in light of the new service.
No, thank you for that, Omer. Well, I think that's been a really helpful session, full of lots of advice and guidance. And as Omer said himself, if there's specific queries that you have that you prefer to share privately with Omer and his team, please do feel free to get in touch. Obviously, Omer's details are on the slide in front of you, and obviously we can share Freya's details as well. I mean, before we wrap up, I mean, all that's left for me to say is thank you so much to Omer for obviously joining us today and sharing that wealth of knowledge. Thank you to everyone who's obviously joined and participated in today's webinar as well. We will be able to make a copy of this webinar available to view on our website in due course. So again, if you need to refer back to anything, then obviously please do visit the website, and you'll see the webinar on there. I mean, all that's left for me to say is, as I said, this is part of the wider piece of work we're doing with the West Midlands Combined Authority in helping businesses prepare and adapt to the new trading landscape post-Brexit. So we do have another webinar coming up tomorrow on Brexit grace periods, which I believe my colleague Demi has shared details on in the chat box. So again, if you'd like to come along to that, then do let us know. And finally, what we'll look to do today is send out a survey which will go to all the participants who joined us today. It'd be great if you could fill that in, just so we can get your feedback on how we can obviously use this information and shape these webinars to help businesses moving forward. So all that's left for me to say is thank you very much to Omer, thank you very much to his team, thank you very much to everyone who joined us today, and hopefully see you again soon. Thanks everyone, have a great day.
Thanks, Raj. Thanks everybody.
Thank you. Cheers.